And Greta, everything looks good with the slideshow. Yes.
Yes, everything looks good.
Great.
And I can, we can start with the poll again and get going here, and I'll make sure to let folks in if they arrive.
Sounds good. So welcome to the Essentials of Land Use Planning and Regulation training. I'm Emily Kloft. I'm a regional planner with NRPC. And Greta, if you want to introduce yourself.
Yes, hi, I'm Greta Brunswick. I'm a senior planner here at NRPC.
Great. If you haven't seen already, we have our poll running as introductions for this meeting. Essentially, this training is a review of the basics around land use, zoning, and planning. And it's a great refresher, or if you're a new board member, learning new information. We'll be discussing sort of 4 chapters of information this evening: planning for a vibrant, sustainable community, roles and responsibilities, implementing the plan, and meetings, hearings, and due process. And after each section, we'll hold some time for questions. If you have a question, feel free to hold it for then, or put it in the chat and we can address it at the end of that section. Yeah, I see one more person just in the waiting room.
I just admitted them, Emily, so I'll take care of that.
Great. Okay, sounds good. This keeps popping up on my screen there. So I'll go ahead and get started then, since we have a good group of folks. So our first section is planning for a vibrant and sustainable community. This image shows a painting from Grandma Moses and how she envisioned a vibrant community in the early 1900s. Since then, a lot has changed, but what hasn't changed is that we're trying to look at what type of community we have and how municipal planning and land use regulation can get there. So I guess if anyone wants to chat or say what vibrant and sustainable means to you, feel free to do that. Feel free to put that in chat as well. And really, since the 1900s, the tools we use to achieve these types of goals for our community have been codified into statute. So as a brief review, Vermont has been planning since the 1920s. In 1921 was when the Vermont legislature first authorized the creation of municipal planning commissions and municipal plans. In 1931, so 10 years later, zoning regulations were authorized. And then in 1968, the current chapter in which our zoning and land use and planning regulations sit, the Municipal and Regional Planning and Development Act, was passed, which include things like the purposes of planning, the contents that should be in municipal plans, the adoption process, and what types of zoning reviews were authorized. In 1988, there was a substantial overhaul of Chapter 117 focused on planning. And in 2004, there was another substantial overhaul, this one focused on zoning. So the 1988 overhaul included things like the state planning goals, and the zoning included things like process changes to zoning and more focus on affordable housing. Since then, we've seen sort of continued smaller updates. Act 179, which was a few years ago now, which had a focus on affordable housing, as well as the pending housing bill that the legislature passed this year around affordable housing and housing density. So moving a bit into municipal plans, at the basic level, a municipal plan is a guide for accomplishing a community aspirations and intentions through public investment, land use regulations, and actions the town can take to achieve its vision. A municipal plan really considers all of the different areas of the town to be planned as a single unit to meet the needs of the community and develop a community-wide vision. It's an inclusive process that involves lots of members of the community, empowers communities to respond to changes in ways that reflect their goals and values, and allows communities to designate areas that they want to maintain, see evolve, or transform. Development will happen and will be planned by anyone, whether that's individuals, businesses, the town, or a combination of all of those. But no one would start building a house without having a blueprint. And it's also important to have a plan for development in your town. to help grow and guide future development. There are a number of benefits to having a municipal plan, including that you can adopt zoning and subdivision regulations. The Act 250, which is the statewide development law, applications must conform to your plan, and your plan is also considered in Section 248, Certificate of Public Good Processes, which is the statewide permitting process for energy projects. And you're also more competitive for certain grant applications like the Vermont Community Development Program funds. The planning process that leads to the creation and constant update of the municipal plan is cycle. The municipal plan is a living document that's constantly cycling through these steps, from assessing the community, developing the vision, identifying your goals and objectives, and mapping out the future and priority items, to implementing your plan and then reviewing your plan. Once you've got an adopted plan, it's a great practice to review your plan at least annually to see what your implementation steps were and what actions that you've been taking towards those, and if those are relevant or not. And that really helps as well as you start to look at updating your plan, doing a more in-depth review to see what needs to be updated. So in order to work towards this common vision, it's important to have input from the community and coordination between other boards, commissions, and neighboring towns. All of this is really laid out in the Vermont planning process goals that are in Act 117, which are, or Section 117, sorry, coordinated comprehensive process to guide decision, citizen participation at all levels, considering the use of resources and the consequences of growth and development locally and beyond, and working with neighboring municipalities in the region to implement plans. We have this quote, when it comes to planning, if you're not doing it with people, they think you're doing it to them. People will generally resist change if they haven't been involved in the process, unless they've helped initiate it, if their concerns haven't been addressed. So because of that, a really important piece of your planning effort should be citizen participation, resident participation. And you can want to use a combination of different outreach types to reach all segments of town. And there are many different types of potential participation, and the type that is best for what you for you really depends on what your goal is. So if you just want to inform people about something that's going on in town, you may want to do something like post it on Front Porch Forum or the town website. If you're looking to consult them on an existing idea, whether they like it or not, you could run a survey. If you're looking to generate some new dialogue and obtain advice, you might run a focus group or a workshop, all the way down to collaborating where you have a charrette where you're having multiple alternatives be developed and decided on by the community. And it's really important to think about what you're doing and the type of outreach and matching it to that type of outreach. And NRPC is available to help if you're looking at community outreach as well. And there are lots of ways to engage people in planning. In a lot of small towns, just talking directly to people can be a really effective method of getting the word out. This really helps communicate your message, alleviate any fears or rumors that might be happening, and communicates respect with folks. So for example, you might want to identify some people in town that you know are important, and that if they have the right information, they'll be able to share it with others. Or you might commit to each planning commissioner talking to 10 people about the plan, things like that. You also want to meet people where they are. A lot of people do not want to spend their evenings going to a planning commission or other town board meeting. So meeting people at places like senior centers, schools, grocery stores, and farmers markets, and using language that people can relate to is an important way of doing community outreach. And then where you can bring food, fun, and celebration into your event. So whether that be a potluck or serving pizza, having an art contest for the plan, all of these things can help make an event feel more like a community space and be more inviting and interesting. And then promote in general a culture of communication. Regularly provide updates to residents about important information and town business. provide places where residents can gather, making the town hall usable and welcoming, and support places and events where people can run into each other in a more informal setting. All of these will help generally build trust and a culture of communication in your town. So moving on from outreach, what should your plan include? Well, one thing your plan may include are the Vermont planning goals, which are a set of interlocking goals that are designed to support vibrant, sustainable communities. These include things like available childcare, quality housing, flood resiliency, and safe transportation, amongst many that you can see in this list. Town plans may be consistent with this, and they shall be consistent if you're seeking regional approval of the plan, which we'll discuss in more depth later on. Consistent meaning that it doesn't conflict with the goals and tries to make some progress towards attainment. And I think in general, regardless of whether you're seeking regional approval, these are great things to consider within your plan. And then all plans need to have these 12 requirements, to include objectives, policies, and programs, land use, map and statement, transportation, utilities and facilities, education, energy, economic development, housing, flood resiliency, policies on preserving rare natural areas, compatibility with adjacent municipalities in the region, and the implementation program. So these are the requirements that all plans must have according to state statute. And while these are requirements, in terms of how you format it and how you organize it, you can make it your own. These don't need to be your chapters if you have a different way of doing it. Also note that any state designations, so if you have a village center designation, for example, need to be addressed and mapped in your plan. And as it notes here, there is also an optional opportunity to do an enhanced energy plan. With all these requirements, it can be easy to get caught up in creating a big document that just describes existing conditions in your town. But it's important to remember that you're planning for the future and trying to create a shared vision. So the focus of the plan really should be, what do you want your town to be in the future? So in terms of when you need to adopt a plan, plans expire every 8 years. If you've been around for a couple of years now, you may have noted that it used to be that they expired every 5 years, but it's now 8. And you'll want to ensure that you've revised or rewritten your plan prior to its expiration. At the very minimum, you want to make sure you at least have necessary edits to data and the implementation program. And beyond the time that it might take for you to rewrite and edit your plan, depending on the scale that you're trying to do that at, the adoption process can also take several months. It involves first a planning commission hearing with notice to adjacent communities, 1 to 2 select board hearings, depending on if the community is urban, which is 2,500 people or more, or rural, which is less than 2,500 people. And then usually in most towns, the decision for the town plan is made by the legislative body. So that'd be the select board in most cases. Unless in a few communities, it's voted on by Australian ballot. In those communities, it still needs to be approved by the select board, but then goes to ballot. And plans go into effect upon their adoption. So I mentioned we would get back to the regional approval and confirmation I mentioned, where you have to be consistent with the state planning goals. So a municipal plan can be approved by the Regional Planning Commission if it's consistent with the statewide planning goals, compatible with the regional plan and the plans of other municipalities in the region, and contains the 12 required town plan elements. If you have that regional plan approval, you can also receive a confirmation of municipal planning process if you have that approved municipal plan and the municipality is engaged in a process to implement the plan and is maintaining efforts to provide funding for planning. We meet with communities every 4 years to understand your town needs, and this is where we can hear about the work that you're doing towards implementing your plan that can help us ensure that when your next plan comes up, we can confirm the municipal planning process. And that confirmed planning process allows you to apply for state designations of downtown, village centers, new town centers, and neighborhood development and growth centers. You can apply for municipal planning grants. You can have impact fees, and the plan will also be considered by state agencies in their planning. So those are all additional benefits that come from having a approved municipal plan and a confirmed municipal planning process. beyond the benefits that we talked about from just having a municipal plan. So all of this is talked about in greater detail in the state planning module for the municipal plan, which is linked here and is a great guide. Do we have any questions on this first section?
Nope.
Okay, I'll move on to the second section now, and if something comes up, you can get back to it. So this section focuses on roles and responsibilities of different boards in town. So you may remember from your high school civics, federal level, the government has three arms. It's the legislative branch, which is Congress in the federal government that writes the regulations, the judicial branch, which is the Supreme Court, which interprets those regulations, and the administrative, which is the executive branch, the president and the cabinet and all of that, that administers and interprets those regulations in a non-discretionary way. So at the local level, in terms of planning and zoning, it typically looks something like this. You have a legislative body that can be a select board, a city council, or a village trustee. You have a legislative branch that is usually a role of the planning commission and select board, a quasi-judicial branch that is typically a development review board, or in some communities, it's the zoning board of adjustment and planning commission, and an administrative branch, which is for planning and zoning, is the zoning administrator who interprets regulations in a non-discretionary way. So to go into some further detail here, the legislative function in planning and zoning, which is done by the planning commission and the legislative body, the planning commission prepares the municipal plan and development regulations. They can prepare and edit a capital budget or program, and they can also prepare other studies. The role of the legislative body is to review and edit and adopt, or in some cases send to voters, the municipal plan and zoning bylaws and development regulations, and also preparing, editing, or adopting a capital budget or program. And again, when we say legislative body there, we mean select board, city council, or village trustees. And then this quasi-judicial function resides in most of our communities with the development review board that completes site plans, subdivisions, conditional uses, applications for lots without frontages, variances, or appeals of ZA decisions. In some communities, it's split between the planning commission and zoning board of adjustment, where the planning commission has responsibility for site plans, subdivisions, and lots without frontage, and the zoning board of adjustment has responsibility for conditional uses, variances, and appeals of ZA decisions. There are some advantages to the development review board model in that it simplifies the processes of the boards and the roles of the boards and the processes for applicants. And it allows the planning commission to focus primarily on its planning functions. And membership can overlap between the two boards. So if you switch models, it's not that folks on the planning commission interested in these issues could also join the DRB. And then the administrative function is the zoning administrator, who issues permits that for zoning regulations that have been determined that can be approved administratively as long as it meets the required density, dimensions, and uses prescribed within the regulations. And they also will conduct enforcement, they assist applicants, and in some towns they may staff the DRB, PC, or ZBA, or have other duties. And then finally here, just a note on some of the terminology we use. In common usage, regulation, bylaw, or ordinance are all pretty much mean the same thing, but in the specific context of Vermont statute, bylaws are used to refer specifically to zoning, subdivision, or other land use regulations adopted in conformance with the municipal plan, whereas ordinance is used to refer to regulations adopted directly by the select board and other municipal legislative bodies, such as public works standards and noise ordinances. And regulation is used as a catch-all term for all types of governmental rules. So there are some key differences between bylaws and ordinances. Bylaws allow for pre-existing nonconformities. So for example, if you have a house on a lot and the bylaw changes, you're allowed to continue to operate that house, even if it's now a nonconformity, use it. Whereas ordinances are effective immediately, regardless of prior use. And bylaws and ordinances also have separate adoption processes outlined in state statute. So we're at the end of section 2. Are there any questions on section 2? Okay, not hearing any, I'll move to section 3. So section 3 is really about implementing the municipal plan. So you have adopted your plan. What do you do with it now? And really, there are 2 categories of implementation. There's non-regulatory implementation, which can focus on things like improving public facilities, informing and engaging citizens, and supplemental plans. And we'll talk a little bit about this here, but the main focus of this section is on regulatory implementation through zoning and subdivision bylaws specifically, but you can also implement through flood hazard bylaws and local ordinances. And the goal of both regulatory and non-regulatory implementation is to meet those goals and aspirations in your plan. And that is what then shows that you're part of a planning process that can be confirmed by the Regional Planning Commission. So why have local land use regulations? They can really help implement the goals and visions of your plan. For example, if your goal is to promote a walkable, compact development, you can have regulations that ensure buildings and driveways and streets support the desired pattern of development. If you have a goal to protect natural resources and minimize fragmentation of farmland, you can have regulations that limit the layout and length of new roads and driveways or support uses that are compatible with maintaining farms and forests. There are also some changes to how Act 250, the statewide land use system, review happens for communities that have zoning and subdivision regulations versus those who don't. So for commercial Act 250 projects, Act 250 would be triggered only on projects greater than 10 acres of size versus for communities that don't have development regulations, it's 1 acre. And for subdivision, it's 10 lots that triggers Act 250 review versus 6 lots for communities without land use regulations. So it limits the sum of development that might be otherwise reviewed by Act 250. So what are some of the important limits of local regulation? So land use regulations can tell people what they can or cannot do with their property, but you can't deprive landowners of all reasonable use of their property because this would be considered a government taking, which is illegal under and unconstitutional under the 5th and 14th constitutional amendments in the US Constitution. So there's been over 25 court cases clarifying what reasonable use of property means. This can include whether the law denies a property owner all economically viable use of the land. The courts have considered the extent to which the property is limited without the effect and the extent to which the law will fall under a governing body's police power to protect public health and safety. And there was actually a court case filed in South Burlington recently where a landowner said that they had been deprived of all reasonable use of their land and that it was a governmental taking. So that's one thing to consider when you're making your regulations. Second is that the land use regulations can only regulate what is enabled in Vermont statute. And that's because Vermont is a Dillon's rule state as opposed to a home rule state. And that means municipalities can only regulate what is specifically enabled by Vermont statute. And then Vermont statute places specific limitations on local regulations. For example, you are required to, it protects home occupations and home daycares. It prevents discrimination against certain affordable housing and certain ADUs and multi-unit dwellings in certain circumstances. If, for example, have to allow an ADU anywhere you allow a single family home. It allows for the continuation of non-conformities and development of small lots and development of lots without frontage if there's adequate access. It allows regulation of public facilities only when but it shall not interfere with their intended functional use. And you can't regulate accepted agricultural and silvicultural practices or applications requiring a certificate of public good. So farming, forestry, and energy projects in most cases. So to move on to some of the process of how a local zoning application will be reviewed. The zoning administrator will receive an application and then they will determine whether it is an administrative review or if it needs to go to a quasi judicial review by the DRB or ZBA and PC. So if it is a permitted use, for example, under administrative review, the zoning administrator will conduct the review and either issue or deny the permit. At that point, if an interested party or the applicant doesn't like the decision, there's an opportunity for appeal. For quasi judicial applications, the zoning administrator will send it to the DRB or the ZBA and PC to conduct review under a quasi judicial hearing. They'll issue a decision panel, and there's also an opportunity for appeal. And in that case, typically the ZA does not issue the permit until all of the board approvals have been attained. So there's many different types of review that can be used on land development, where land development is defined as subdivision of parcel into two or more parcels, construction, reconstruction, or conversion, structural alteration, relocation, or enlargement of a building or any other structure, mining, excavation, and landfills, and also change in use to the building or structure, land, or extension of the use of land. So zoning applies to subdivision, it applies to resource extraction, building, but it also applies to the use of those buildings. And the most common types of review are shown in this table. We have permitted use, which are permitted administratively, and usually just require a permit with limited review. Conditional use, which considers external impacts of the use and compatibility with the surrounding land use. One of the most common tests being, does it meet the character of the area, for example, although not the only one. Site plan review, which considers the internal impacts of the use by looking at the design of the specific parcel. Variances, which are required by state statute and allow for some relaxation of dimensional standards in very specific uncontrollable circumstances. Because those circumstances are so specific, many communities also choose to allow for waivers, which are more flexible standards that allow for some of relaxation of specifically defined rules like dimensional standards, as long as there's a clearly defined process and standard for how that waiver will be applied. So that can allow more ability to be flexible than there is in the variance process. And then a planned unit development, which is a system that allows for flexible development plan for specific projects, where some rules may be modified as a carrot for implementing good site design. Probably the most common form of this, which you may be familiar with, is a conservation subdivision, where lots and units can be clustered on smaller lots than would be normally allowed, as long as the remaining land is restricted from further development. And then subdivision, which controls the pattern of future development. And just to speak a little bit more to the variance versus waiver issue, be specific physical circumstances or conditions that make it impossible to develop in strict conformance to the provisions of a bylaw, and that has to not have been created by the applicant. So it's a very strict standard. So moving back to what happens in these quasi-judicial applications, after you've held your public hearing, you will have to make a regulatory decision, and that decision needs to be in writing and contain the findings of fact on which each decision is based, and also the conclusion of law on how the bylaw applies. So the fact of the matter that was discovered, and then what that means based on the bylaw. So determining these findings of fact and conclusions of law are the board responsibility, not interested parties or anyone else at the hearing. They need to be based on the review standards in the bylaw. In some cases, minutes can suffice as long as they include these elements, but they're only appropriate where decisions are issued in public deliberation. And they need to memorialize the concurrence of the majority of the board, which means if the vote was 5-4, for example, it should indicate that the vote was 5-4, but it doesn't need to name who voted for or against, and it doesn't need to be signed. One really important thing to understand is that the official decision needs to be issued within 45 days of the close of the final public hearing. It does not need to be issued on the same night of the hearing. So if you need to take your time to make that decision and to write it, that is fine. We'll talk a little bit more about not making the same decision on the same night later. And then it's important to identify who in your town is responsible for preparing decisions. It's a really big responsibility, especially if it's done with volunteer board members. It's ideal for when there is staff to prepare written decisions, although that's not always the case. And in some communities, the zoning administrator plays this role. So as I mentioned before, there is opportunities to appeal within the process, and that can be either at the local or state level. So if something is permitted administratively, the decision of the administrative officer, the zoning administrator, can be appealed to the Development Review Board or Zoning Board of Adjustment. And that board can make a decision as to whether the zoning administrator made the right decision or not. If that is then appealed, or in the case of a application that went right to quasi-judicial review, that decision is appealed. It will be appealed to the Environmental Division of the Superior Court. And the applicant and any interested parties, which we will discuss what that means later, have the ability to appeal the act or the decision of the DA and the decision of the quasi-judicial board. So when it goes to state review, this is at the Environmental Division of the Superior Court, also sometimes known as the Environmental Court. That was their old name. Unless you are from the town of Montgomery, who has adopted the Municipal Administrative Procedures Act, the case will be heard de novo, which means that all of the information and facts heard again at that level. For Montgomery, because they have the Municipal Administrative Procedures Act, that does not apply. And when local decisions are appealed, a municipality does not have to defend a decision or put an appearance in court, although it is strongly advised to do so. So who are the people who can appeal? You can only appeal a local regulatory decision if you are an interested person, which is defined as the applicant, the municipality and any adjoining municipality, property owners in the immediate neighborhood of the subject proposal, a petition of 10 persons who are a combination of either voters in town or property owners in town, and any department or administrative subdivision of the state owning property or interest, and the Agency of Commerce and Community Development. To appeal to the Superior Court Environmental Division, you also need to have participated in at least one of the hearings, and that could be that you attended the hearing and provided feedback, or also written participation counts. Local boards do need to document attendees at public hearings and document whether they're seeking interested party status, and those who are should be sworn in, but they don't need to make the determination of who is an interested person at that meeting. They can leave this up to the environmental court if there is an appeal. This applies to all the communities in our region except for Montgomery. So then a brief thing on non-regulatory implementation. This can often complement regulatory implementation, or sometimes it can even be the main focus of plan implementation. There are many options enabled in state statute. For example, either the Planning Commission or the Select Board, or both Planning Commission and Select Board, can work on a capital budget or program to ensure that the goals of the plan are achieved with spending. They can use tax stabilization contracts to create favorable tax provisions, to create incentives for certain land use, purchasing and acceptance of development rights. You can purchase land for conservation or for public facilities. You can have supporting plans, such as, for example, a detailed plan for a village or evaluating the feasibility for a public wastewater treatment. And you can even create other advisory commissions, such as a conservation commission, housing commission, or another permanent or temporary committee that helps address some area of concern. And there's more information here at the Vermont Land Use Planning Implementation Manual, which provides some topic papers on regulatory and non-regulatory implementation strategies, which is available online, and towns should have a paper copy somewhere as well. So any questions on that section? Okay, not hearing anything. I'm gonna switch it over to Greta.
Okay, hi, everyone. Just give me a moment while I pull up the PowerPoint presentation. I'm going to be doing the final section of our presentation tonight. So if you think of any, Emily, did you close it?
Oh, hang on. Okay, you should be good now.
If you think of any questions, you can still ask them now while we get sorted here.
While Greta does that, I'm just looking at the results of our poll. Looks like we're pretty even mixed between Planning Commission and Development Review, and most folks have either somewhere between less than 2 years or 2 to 5 years, which is like perfect timing for this training.
Great. Awesome. So we're going to get started now on the final section, looking at meetings, hearings, and due process. So due process simply means that all proceedings are conducted fairly for everyone. Due process is guaranteed by the Fifth Amendment of the U.S. Constitution. So it states no person shall be deprived of life, liberty, or property without due process of law, and it's applied to all states by the 14th Amendment. So what we need to ensure to protect due process is that all business of public bodies, that there's adequate notice, that there's opportunity to be heard, that there is maintenance of order, there is management of evidence, and management of conflicts of interest. So by doing so, we will ensure, yeah.
Sorry, did you mean to be screen sharing it? Because we don't see it. Yeah.
Oh, I did. Thank you.
Okay, yep, sorry.
There we go. This is the only slide. This is all we've missed. So ensuring the protection of due process. So Vermont's open meeting law requires that all meetings of public bodies be open to the public unless a specific exemption applies. Sorry, one second. There we go. And so Vermont's open meeting law includes all of these due process protections. In order to do so, a public body must provide advance public notice of meetings, discuss all business and take all actions in open meeting unless an exemption applies, allow members of the public to attend and participate at meetings, and to take meetings and make them available to the public after the meeting. So I'll touch briefly just here on that there are exemptions. Most public meetings that boards will conduct, public bodies will conduct, are subject to the open meeting law. There are a few exemptions. Certain electronic communications, so long as it does not involve business of the board, can happen, such as coordinating the agenda on email. But otherwise, you need to be careful with electronic communication and not discuss the business of the body, of the board. Executive session is also exempt. So that's typically most appropriate for a select board for making confidential decisions, and there are specific statutory guidance for what types of decisions can be made in executive session and how you may enter executive session. And then also deliberative session, sorry about that. And so that is for quasi-judicial boards, so your development review board and your zoning board of adjustment, to deliberate on evidence presented at a public hearing. So applying the open meeting law applies to all public bodies. And so there's a few questions that we need to ask when thinking about applying the open meeting law. Number one, am I on a public body? Is the board I'm serving on a public body? And then number two, are we meeting? And so we're going to review that information right now. So any board, council, or commission of the state or one or more of its political subdivisions is a public body. So the select board, the planning commission, the development review board, any subcommittee of the select board or the planning commission would also consider to be a public body. Does anybody have any questions on a board and whether or not it is a public body? I think these are really important. So we're here tonight because you're probably serving on a planning commission or a development review board. So we know that you're a public body, but are you meeting? So you are meeting when you are gathered as a quorum to discuss business or take action. And so we do need to be careful when members of a public body may gather in a situation where it was not a warned meeting, a noticed meeting. And if a quorum is present and ends up discussing the business of the public body, then that ends up being an open meeting violation. So that's something to be very careful if you are on a public body, on the planning commission, on the DRB. So things to look at are email communications. I just noted where there is that exemption if you're just coordinating the agenda of a meeting, but certainly you are not to be emailing with all of the board members and talking about the public body, because that would not be in a public meeting and therefore would be a violation, and it's not fair and does not protect due process. The other thing we need to be careful about is serial or daisy chain communications, which could be considered a open meeting law violation. And that would be where if the chair wanted to prepare for perhaps a conversation at an upcoming meeting, but wanted to just poll the board members first and get a sort of feeling about how people are feeling. So they might email each person individually saying, hey, what do you think about this change to this land use district? Do you think we should do it? That would still be a potential violation because it did involve, even though it was serial or daisy chain, communication about business of the public body via email. So that's something to be careful of, not something that you should do. Also, you need to be careful with social media, Facebook chats, and the potential to for board members to communicate in a way that would be, the business of the public body by a quorum in those manners, whether it be communicating via comments on Facebook or other ways, sort of text, group text, things like that. Another important thing to note is that board meetings and hearings are run under parliamentary procedure, as outlined in Robert's Rules of Order. And so the reason that we do that is to protect due process. Every board member has a right to understand what the business that they are going to be deciding on and voting on. And Robert's Rules of Order and parliamentary procedure helps do that. And it also ensures that everyone is treated fairly and equally. And so generally that flows with a chair running things smoothly, board members contributing to the discussion on agenda items. And in order to take action, someone has to make a motion, second that motion, then there's an opportunity for discussion, and then there's that vote on motion. So that protects the orderly process, ensures that things happen fairly and equally, protects due process. So as a planning commission and DRB members, there are going to be meetings and hearings that you do as business of the board. So we have regular meetings when a quorum of members of the board meet, and you've noticed that meeting on an agenda. So you meet and you discuss business or take action. Generally, that's a legislative function, and all public bodies do that. They have regular meetings. Then we also have legislative hearings and quasi-judicial hearings. And so Emily reviewed these briefly in the last section. So we have the Planning Commission and the Select Board that may have legislative hearings on a draft plan or zoning bylaw to receive public comment. And then we also have the quasi-judicial hearings, which are held by Development Review Board members to hear from parties seeking board approval. So it operates much like a courtroom, and you're hearing evidence on whether a particular project meets the standards in the zoning bylaw. And then the board issues a decision. So there's specific timelines for advance notice, which is agenda posting, depending on the type of meeting or hearing you're holding. So we have regular meetings. This is specific to the different types of meetings. We also have specific advance notice required for hearings. So we have regular meetings, special meetings, and emergency meetings. So regular meetings are set on a regular day and time by ordinance or resolution. So typically the first organizational meeting of that board, the board will set a standard meeting date and time. And then after that, you don't need to do a special warning of that meeting other than posting the agenda. So the agenda needs to be posted 48 hours in advance. Special meetings take place outside of that regular schedule. And there needs to be 24 hours notice to the members. And then the agenda also needs to be posted 24 hours in advance. And so you can have a special meeting anytime, but you do need to, you would do that to address a particular agenda item. It's not an emergency, but there's a reason that you need to meet outside of your regular meeting time. And then emergency meetings, this would be something that would be typically only required of a select board. Whether there was a major storm event and the select board needs to meet to figure out how to respond to some flooding or road damage that happened. So only when necessary for immediate action, and public notice must be given as soon as possible. So then types of hearings for public notice for types of hearings. So we have legislative hearings and then the quasi-judicial hearings. And so for plan and bylaw amendments, the legislative hearing that's required, there's 15 days notice. It needs to be noticed in the newspaper and posted in the town and 2 other places, and on the official website if one exists. And they're also for plan and bylaw adoptions, there is a certified mailing at the Planning Commission hearing level that's required to adjacent municipalities, the Agency of Commerce and Community Development, and the Regional Planning Commission. And then for quasi-judicial hearings, we have the 15 days notice, the newspaper of record, 3 places in the town and the official website if one exists. And then the notice also needs to be mailed to applicants and adjoining landowners, and then also posted within view of the nearest public right-of-way. And that's that big P poster, which notifies of the public hearing that is posted. So we have, those P posters that are available to municipalities. Zoning administrators are commonly, calling our office and saying, hey, we're out of P posters, we need them. So that's a service we provide to municipalities, is that form for posting within nearest public right-of-way. So there are some changes made relating as a result of the pandemic, but then have been made they're temporary, but they've been extended by the legislature through July 1st, 2024. And I think that there are many folks that are looking to make them permanent. And so agendas right now, they need to be posted in or near the municipal office, posted in at least 2 other places designated for posting, and posted to the official website if one exists. But the temporary changes, which have now been extended to July 1st, 2024, are that the agenda must include details for direct telephone and electronic participation. So remote meetings are possible. There's no physical location required. So you may hold a entirely remote meeting without requiring there be a physical location. And that you can use 2 electronic places for posting that agenda rather than physical places. And so the content of the agendas, the public must be reasonably informed about topics and actions. So certainly if there's anything on the agenda where there's going to be a vote or action taken, that needs to be on there. But if there's also other major discussion points that you know you're going to talk about, those should be on the agenda as well. And the first agenda item should also be that any changes or deletions or additions to the agenda, that should also be the first agenda item. And that is so that, you know, if someone comes to the meeting, they can come to, they know that the meeting, if they're coming to a specific agenda item, they know if they stay for that first agenda item, that is the only time the agenda is going to change. So that's, again, a due process protection. And then also the location of the meeting must be included. On the agenda is the traditional, that's actually not, that's so that it's been, the open meeting law change has been extended to July 24. We don't need that physical location. So minutes, another way of ensuring.
So yeah, I get that you don't require the physical location. If you have a board like Berkshire's that always meets in person, is that board that meets in the town hall required to offer electronic access?
So the town has to offer, if you're not going to meet physically on the agenda, you must provide telephone and electronic internet access.
Okay. If we do meet physically, we are not required to offer electronic
No,
access.
you're not.
Thank you.
Yeah. So minutes, another due process protection, a way to allow for the business of the public body to be transparent, and so that the people of the municipality can know what business the town is conducting. The content of minutes, they don't need to be a transcription, but the minimum requirement is that all members in attendance, the names of other active participants, the motions, proposals, and resolutions. So a brief discussion that supports or provides context around all motions, proposals, and resolutions that were made, and the results of all votes. So you don't need to give necessarily the names of who voted how, but you do need to show the result of all votes. And when there is a motion made, it is helpful to have like a brief, context to provide for the discussion that resulted in that decision. Requirements in terms of when they're posted, they need to be available within 5 days, posted on the website within 5 days, and maintained for a year. So they need to be available at the town office. So if someone wants to come to the town office and see the minutes, they need to be there, and they need to be on the website and maintained for a year. So also now we're getting to the electronic meetings. Again, these were changes that started, there used to always have to be a physical location. So as a result of the pandemic, this change has been extended to July 2024. And there are many folks that think that that it should be a permanent change. I'm curious what folks here think. So electronic meetings are quite common now. Hybrid meetings are quite common now. They're allowed under the open meeting law. You don't need to have a physical location, at least for now. Public access by telephone must be provided, not just a Zoom link. You must also provide that phone number. And then at least for the legislative body and school board, just a note that they must be recorded. And roll call votes are required for votes if they're not unanimous. So you need to do sort of that straw poll first to figure out if the vote's unanimous, or do the vote. And if it's not unanimous, then you have to go through the roll call. So electronic and hybrid meetings. So hybrid meetings can be challenging. I know a lot of municipalities now have purchased an owl to help make hybrid meetings more just easier to participate in, so that you can see the people in the room and the people participating remotely. So it's important to think about the experience of the people attending meetings remotely and in person to ensure that each member can hear and be heard. You want to make sure that you're conducting effective meetings, that you're conducting meetings that are upholding due process and protecting due process. And so thinking about ways that in tools you can employ that will ensure that, because you don't want to have the impact by making things a little bit more convenient, but then having, having the meetings be conducted less fairly or something like that. So there's some best practices around using Zoom. There's some security and safety features that you can ensure, whether it's ensuring that or enabling the waiting room, assigning a moderator so that you have some help, designated method of communications for access problems. Like, so if someone's having trouble logging in, so where can they go? Who can they call? Ending the meeting if the connection cannot be maintained, because it's better to end the meeting than to hold a meeting that is not fair and that not everyone can access, because that would be a violation of the open meeting law. Ensuring that everyone understands the ground rules, and for that sort of different hybrid situation, maybe some folks are not really used to that. And then enabling closed captions. And some meetings, like for example, if you are holding an electronic development review hearing, you may want to disable the chat function. So that's something to consider. So this slide is looking at the flow of a quasi-judicial public hearing. So this is where your board is operating like a mini, perhaps a little less formal courtroom. Emily, I just noticed before I get into the slide, is there anything on the chat? I noticed there's a few things there.
Yeah, someone, Mike had a question. When does an addition to the agenda violate open meeting laws?
Okay, so there is that first agenda item that allows you to adjust the agenda. And that is the only time that you may adjust the agenda. And any other time that you adjust the agenda, like you can't do it later on in the meeting. So, and that would be a violation of the open meeting law. That said, best practice is to not add any agenda items that are action items without warning them with the full notice. So it would not be best practice to, in that even first agenda item, add a decision item to the agenda. Reordering it, adding something under other business, a discussion item like that, but do not add an action item that night. That should be warned as its own separate agenda item. It should be on the agenda. Reordering is one thing, but don't add any new action items the night of. Does that answer your question? Okay.
Yes, Greta, thank you.
Yep. And then I think Russ asked his question, and that's it. Okay. So now moving on. So rules are stricter for quasi-judicial hearings because the board's deciding how to apply the law and needs to protect due process rights of parties. So this is just a typical flow. The chair is going to open the meeting. The applicant is going to present the proposal. What is the project? It's common for the chair to turn it over to the applicant to give a little presentation on what the project is. Sometimes this could be an engineer acting on behalf of an applicant. Then it's the board member's responsibility to ask questions that they may need. I mean, that they're collecting evidence and testimony in support of whether the project is in compliance with the zoning standards. There's always opportunity for public comment, and this may be managed differently by board members, but there certainly needs to be, and it's good practice to have a time for when public comment is appropriate on the agenda. And to appeal, you have to seek interested party status. but many communities aren't making that determination. So you're generally hearing from anyone in the public and you're not limiting that participation. And then the chair is going to close the public hearing and open deliberations. And so deliberations are, when that public hearing is closed, deliberations are exempt from the public meeting law and they can be conducted privately. And so it's certainly, we think that it's a good practice to conduct your deliberations privately. Take that time as a board member to deliberate together, and you have 45 days before the decision is required. So I think that it can result in a better decision, a more defensible decision, if you do take that time. But public deliberations are allowed, and some boards decide to deliberate that same night after they close the hearing. So opening a quasi-judicial hearing. Now I'm reviewing this because it is helpful to make sure that your hearings are orderly, so that I'm not sorry, I still have my comments up. So it's important to ensure that the hearings are orderly, so that the applicants, so that members of the public, interested parties, have a fair proceeding and equal access to information. So a chair is typically going to review the order of events, remind of the importance of order, make copies of the rules of procedure and ethics policies available, which, by the way, are required for board members. So if you are a new board member and have not seen a copy of your board's rules of procedure and ethics policies, ask your chair if your board has them. And if they just have forgotten about them, or no one knows where they've gone, that can be something that is next on your board's agenda. And we have templates and can help you put together a rules of procedure and ethics policies if you're not sure where they've gone or would like to update them. Review the definition of interested persons and ensure documentation of all participants, and administer oath for those interested in seeking interested person status. And then requesting disclosure of conflicts of interest or ex parte communication. So we know that conflicts of interest and ex parte communications are something that happens, and the best way to manage them is to make them like a normal part of board business, so that it's not so no one has to feel shy about disclosing a conflict of interest. It's something that happens. It's a normal proceeding. People disclose their conflicts of interest and business proceeds. So the role of the board chair is an important position, and they do have a role in ensuring an orderly meeting and hearing. A good chair administers the agenda, keeps board members focused on the issue at hand, and ensures the board finishes on time. So one tool that the board some tools the board can use are restating the question, asking for discussion, encouraging discussion without giving or waiting to give the board chair's opinion till later, sort of facilitating the discussion of the other board members first, and bringing the board to resolution after discussion. So coaxing a motion. So when the discussion seems to be just cycling, sort of asking for that motion and sort of letting the board know you think that it's time for a decision. So these are things that will ensure an orderly proceeding. Yeah. Did you have a question? No. And then the board members also have an important role to ensure an orderly proceeding. In order to determine a project's conformance with your regulation and protect due process, board members are going to be listening to testimony and evidence, engaged and asking questions, ensuring that they're on task in determining whether the project is conformance with the zoning regulations, because that is the issue here, and not whether or not you think this project otherwise should happen. Does it conform to the zoning regulation? Keeping
Can you give us
eye-
a little guidance on what constitutes a conflict of interest? And what's
Yeah,
the point at
I'm
which a
actually
board
getting there.
member,
I have a whole
what's the
slide
point
on
at which
that.
a board member should recuse themselves?
Yep, I have a whole slide on that, so I'll be there right in
Awesome,
in a
thank
second.
you.
Yeah. So being aware of conflicts of interest and recusing yourself, basing the decision on evidence presented, and not prejudging a matter or publicly expressing opinions on a pending case. Everyone has opinions, but we need to ensure as a board member that we're not prejudging and we're, looking at the case at hand and whether it complies with the zoning bylaw. Deliberate, so I'll be there in a second, Russ, so I'm just going to finish through this slide. So deliberative session, as I noted before, is an exempt from the open meeting law. There's no requirement for notice or minutes. So once the DRB has closed its hearing and entered a deliberative session, they can meet without notice to discuss the application and to the evidence and testimony and to write the decision. They have 45 days before that decision needs to be issued, and they do not need to have to reveal how the board members voted. So you need to have a concurrence of the majority by indicating what the vote was, but you do not need to show how board members voted. Another thing that I think I failed to mention that I think it's really important for board members to take time at their public hearing and understand that a public hearing doesn't need to be held in one night. And so public hearings can be continued to another date and time certain without having to rewarn the hearing if they note that date and time during the open public hearing. And so that ensures board members are going to have enough evidence and testimony to make a good and defensive decision. So don't, and also ensures perhaps that the hearing isn't going to go on for too long when everyone's just going to be too tired to think straight. So it's important to hold the hearing. It's okay to close it at a certain, reasonable hour and continue not close, but continue the hearing to another date and time certain. And there will be an opportunity to hear additional evidence and testimony. Perhaps there's some questions or additional information that's being requested. When the hearing is finally closed, that's deliberative session. It can be held privately. It's exempt from the open meeting law. Here we are, conflicts of interest. So conflicts of interest can impact the fairness of a proceeding, and it's important for board members to understand what constitutes a conflict of interest. So there's several different types. We've got a financial interest, which could be direct or indirect. And so it could be that you yourself are the applicant, or it could be that your brother-in-law is applying for a conditional use permit for a new business in town and is going to benefit. That's sort of related to personal and financial. You could have a known bias or prejudice on a particular project. And then I'll talk about ex parte communication in a minute. What's really important to understand is that it's less important to really define and determine whether or not there's, yes, definitely a conflict of interest. Is there a perceived conflict of interest? Could there be a perception by a member of the public that your decision as a board member is going to be impacted by some sort of influence or benefit or conflict? So are you going to benefit financially from a business being approved? Do you work for that business? Do you, in some manner, are you an attorney? Are you an employee? However, did you own the land that it's being built on? There's a variety of different ways. Is it a family?
How about being an adjoining landowner?
So that's the thing where could it be perceived? And I think it depends, but so you have to put yourself in sort of the average, public community member. could they perceive that you might be influenced as an adjoining landowner by the outcome of this application? I think, I mean, in most cases, I think yes, but I can't say that all the time. And it's up for that landowner, or excuse me, it's up to that board member to voluntarily say, there could be a potential conflict here. I'm going to recuse myself. And the idea is that you don't have to say there's definitely a conflict, right? It's not about that. If there is the potential for a perception of a conflict, you're going to uphold the fairness of your proceeding. We want the public trust of your development review proceedings as a community. You want to ensure that's your job as a board member, to ensure that the proceeding you're conducting is going to be trusted by the public, is going to be conducted fairly. And so in doing so, we want board members to identify those situations where those conflicts could be perceived, whether it's something that the community just knows you're really opinionated on, and everyone might just know that this person's just really anti this type of development and it's just not received fairly, or whether it's a personal interest because you're a budding landowner and this project's really big and it obviously is sort of going to have an impact somehow on your land.
You're saying there's judgment there. An adjoining landowner can sit on something involving a quote small matter, but not a large matter. I mean, this is very real because of the pattern of land ownership in Berkshire and the fact that I'm an adjoining landowner to the largest farming operation in the town.
Right. So to some extent there is, I mean, yes, there's judgment in determining conflicts of interest. And I think that what I'm trying to say by saying is their perception, I'm trying to set, make a very conservative bar in when our recommendation is that there be a very conservative bar in when you disclose these conflicts of interest, but it should be the board members with the potential or perceived conflict of interest responsibility to identify those and disclose those. And it doesn't mean that, there could be situations where you say, okay, well, this isn't perceived and I'm going to disclose this, but I'm not recusing myself. But it's really the decision of that board member. And my recommendation is to think about public trust and fair proceeding. And if you were a member of the community, if you were, what would you see as, if you would see a conflict there, recuse yourself to be safe and make it. And that's why, so one thing that's important to talk about relating to conflicts of interest is alternate board members, because when we're talking about decisions made by the DRB, we start having issues of quorum if board members need to recuse themselves because of conflicts. And so if you have alternate members, this allows for quorum to still be met and alternates to step up and fulfill that role. So that may mean continuing a hearing, but you can also, as an alternate, you can listen to back tape if a hearing has already started and participate at the next meeting. So alternates are important. Did I answer?
Okay.
Did I get?
Thank you. That's
dive into it enough for us?
That's helpful. I think our practice has been defined that we disclose who our neighbors are, but there's a level of practicality that we wouldn't,
Yeah, I mean, I understand that in small towns, if it ends up, you need to do what's right for your community. And if it turns out that, everyone's neighbors with everyone and it would just happen too much, I mean, I hear where you're coming from. But I think that you do need to think about each case individually though. And if one might be more of a perception of a conflict, then think about that and recuse yourself if necessary. So ex parte communication is a little bit of a different type of a conflict. And so that's where either before a hearing has closed or after a hearing, but before a decision has been issued, if a board member speaks to someone at the grocery store about the details of the project, that is ex parte communication. And so that's discussion by a board member of evidence and testimony outside of the public hearing. And so that's a violation of the open meeting law and due process. And so we know that it happens, right? You might get, board members, people know you're on the DRB. You might be at the corner store and someone might come up to you and start talking to you about the project. And if you say something before you realize that you shouldn't have, the way to rectify that is to disclose that at the public meeting. So we know that they happen, especially in small towns. And so the way to manage ex parte communications is to, number one, understand what they are, try to limit them, but then if they happen, know how to manage them and rectify them. So that is by disclosing them. So and by disclosing them, I mean, my neighbor came up to me and started talking to me about the project, and we had this discussion. This is what was said. So that what was said is now on the record in a public meeting. So managing conflicts of interest. It's important to know and understand that conflicts of interest and ex parte communication happen. Board members need to recognize them and have a process established for managing them. Rules of procedure should memorialize this process. As I noted, rules of procedure and ethics policies are required. All boards should have them. And if it's been a few years or you don't know, put them on one of your next agendas so that you can have the opportunity to review them together as a board and refresh on what's in them. Ex parte communication is very difficult to avoid, so always disclose, recuse oneself when necessary, and use alternates. So these are just helpful tools to manage conflicts of interest mostly as a development review board. I see a raised hand from Josh.
Hey, thanks. Yeah, I just had a question. So when you're talking about the ex parte communication, you're specifically talking about when there's a review item, an item up for decision by one of these boards. Is that right?
Right. So when the public hearing is still open.
Okay. You're still talking primarily in the context of where there's a hearing, not so much just community involvement outside of a hearing. I'm on a planning commission, so I was thinking more about separate from hearing discussions. Thank you. I think I'm grounded.
Yeah, no worries. Yeah, no, the ex parte is really specific to the development review board function for those quasi-judicial hearings. So there doesn't really exist that same sort of issue for planning commission hearings or other proceedings.
Got it. Okay, thank you.
Yeah. Other than making sure not to discuss business of the public body to meet without in violation of the open meeting law. So you can't meet with other planning commissioners without noticing it as a meeting, right?
Sure. Yep. No, that makes sense. Okay.
So in summary, hopefully you've already in supper, protecting due process. Conducting fair proceeding that protects due process for all will set your town up for a solid land use decisions, less likely to be appealed, or at least the town will be less likely to lose an appeal. So proper public notice is important by posting the agenda and meeting notice. People are given an opportunity to be heard. So boards need to have the structure for allowing the public to be heard. It can be limited. You can still set specific time for public comment on an agenda and limit that time to a certain, to a time limit, but that needs to be on the agenda, and you need to make sure that people are aware that they have opportunity to be heard. Conducting an orderly proceeding So, and reviewing that process with your board, ensuring the chair can sort of help make that happen. Establish a flow for opening and conducting hearings, and reviewing your rules of procedure and ensuring that's documented there so that your process is transparent and everyone understands how things happen. Manage proper management of evidence. So boards need to listen to all testimony and make determinations of fact and apply it to the standards of the bylaw. So that is the job of the board members. And then finally, proper management of conflicts of interest. Ensure the fair proceeding by disclosing conflicts of interest and ex parte communications when they happen. So that is the end of our presentation tonight. Thank you so much for your time and taking the time to come and gain a little bit more knowledge to be effective board members in your communities. We appreciate it, especially with this nice weather that's continued through the weekend. What a treat. One thing we want to let you know is that both Emily and I and other staff at NRPC are here. If you do have questions, you're welcome to email or call us anytime about any questions relating to the topic we've covered tonight. Conducting meetings and hearings, contents of plans or zoning bylaws or implementation tools. There's also a lot of resources available to you in print or via the internet and that are listed on this slide. Essentials of Land Use Planning and Regulation is a primer that was prepared quite a few years ago now. There's a few updates that need to be made to it, but it's still a good basis.
Anyone from St. Albans and Fairfield.
And then also Enabling Better Places, a zoning guide for Vermont municipalities, is a newer publication within the last, I think it was just 2 years ago it was put out. And this is in response to the housing crisis, looking at ways that zoning can be tweaked and amended to allow for more housing options in your communities. It's a dynamic guide. And then we also have templates for plan and bylaw adoption tools and rules of procedure and ethics manual templates as well. Many of these resources are all available at and more are available at the website www.vpic.info. And we will be working with the Agency of Commerce and Community Development and VAPTA, the Vermont Agency of Planning and Development Organizations, to update many of these information sources in the next few years. So stay tuned for that as well. So these are also some links to tools and resources. The Vermont Planning Statute and Zoning Statute, Title 24, Chapter 117 is online. So anytime you want to check the statute, you can go to this website, Vermont Statutes Online. VAPTA is our, or all of the Regional Planning Commission websites are located here. The Vermont League of Cities and Towns frequently holds training and also is available for technical assistance questions. They have staff attorneys that you can email, vlct.org. The Vermont Department of Housing and Community Development also has a lot of great information and programs that's worth perusing. And then the Vermont Open Meeting Law is also, there's a guide that VLCT publishes on their website as well. So that's that last link. And then I guess I will note, we'll be sending this out in our newsletter, and it's also available on the Vermont League of Cities and Towns website, but the Vermont League of Cities and Towns is holding a 2-part training. It is in the morning on a weekday. I think it's a Thursday in June. And they are going to be covering some of the basics that we covered tonight, in addition to a session on the new housing statute that was just pending housing statute that was just passed by the legislature, in addition to a session on regulating short-term rentals. So check that out if that's of interest to you, and we'll be sending it out in a newsletter blast as well. Chuck, did you have a question? I see your hand raised.
Yes, sorry,
That's what you
Greta.
go by. Do you go by? Sorry.
Chuck is right. Yes. I want to apologize. I'm out in the Midwest and I got my times mixed up. So is this recording? Can I get a recording of this?
Yes, we are recording this and we
Okay.
will put it on our website and YouTube
right,
channel.
okay.
So
I'm sorry
no
to interrupt.
worries. No worries.
Sorry.
Have a
Sorry,
nice
thank you.
night.
Okay, thank you.
And then Emily, finally, everyone, Emily has pasted in our training survey, which we share with, which we use to make our trainings better and better serve you. And also we send it to Agency of Commerce and Community Development, and we're required to submit it to them. So please fill it out if you're able. And it's in the comments and you can just click on that link and it's a Survey Monkey.
Yeah, and if you just, because it will disappear once the meeting's over, so you just click on the link now, and even if you're not going to fill it out now, so you have the link, and we can send it out with an email too, but.
Okay.
Okay.
Thank you again so much for taking the time out of your night and for your service to your community as a board member. It's really important. Any final questions? I will stop sharing. And if there are no final questions, then we will let you go. Have a wonderful evening.
Have a
Take
good
care.
night, everyone.
Thanks for your time.
Yeah, thank you.
Thank you very much. Thank you.
Thank you. Take care.
Good. Sorry, I remember that last time. Good news, nobody was on the board there but me from Fairfield.
Okay, but you can, and there's recording.
It's recorded.
That was a perfect way to say it. I'm gonna go out west.